Okay, I think we can go ahead and get started. So good morning, everyone. Thank you so much for being here. My name is Noelle Hicks. I'm a shareholder here at Roberts, Markel, Weinberg, Butler, Haley in our Houston office. And today we are going to give you the tools that you need to make sure that your community or the community that you represent can have the best ACC that it possibly can have. And so I'm going to start off, as we typically do, with giving our disclaimer. Of course, the information that's presented today is the law as it exists as of today, November 14th, 2023. We are presenting this information to you as educational information, and it does not constitute legal advice. So if you need legal advice or if you have any questions about any of the topics that are discussed today, please reach out to your attorney to get those questions answered. So let's go over our agenda for today. First, we're going to talk a little bit about what are ACC guidelines or architectural control guidelines. Should an association have an architectural control committee? We'll talk a little bit about the approval process and violations of that. And then finally, we'll talk a little bit about responding to homeowners with delinquent fines or assessments. Now, today's information is a little bit shorter than usual, so we might have some time at the end for questions. I want to make sure all of those questions are related to the information that we're talking about today. But let's go ahead and get started. So the first question that we need to answer today is, what are architectural control guidelines? Well, a property owners association, and you'll hear me say POA or HOA, it's the same thing that I'm talking about here. But the deed restrictions often lay a framework for the physical appearance of homes in a neighborhood. Now, of course, the deed restrictions also contain other information. So we'll have the use restrictions. We usually have assessments. We find sometimes the powers of the association, the property that's encumbered by those restrictions and things like that. However, we know that, of course, a lot of times here in Texas, some of our associations are a little bit older. And as time goes on, a POA might find it important to actually update the restrictions, or they might find that there are certain provisions that are not addressed in a POA's original restrictions. Things come up. We've had, things like EV charging stations, or, as time goes on, updates are made, new technology comes up. And so sometimes there aren't provisions for that in those restrictions, and we got to kind of figure out how to address those things. And then sometimes we also have those older developments that I'm talking about. They might have some guidelines in place, but they are dated. They only relate to things that were going on during that time period. A lot of times, too, if we look at our restrictions, there are some things that may not even have been contemplated during the initial phase of development. And so, again, there's that need to maybe update the restrictions or find some way to address, new things that come up, in current times or recent times. And then sometimes, there are no architectural guidelines. The developer didn't even consider the fact that there may need to be architectural guidelines. And then finally, we might find that there might be some ambiguity. If there is an architectural guideline, that there's some ambiguity between a provision in the deed restrictions and the guidelines, or that sometimes the guidelines can use as a tool to actually clarify something that's in the guidelines. So there's a lot of different reasons or ways that we can see how guidelines can actually come into play or why they might be needed. And so today we'll talk a little bit about, the importance of those, get a little bit of clarity on why they might be necessary and how they can be used in the community. So, a lot of the issues that I addressed, obviously they can be addressed through creating architectural control guidelines. And so if the association goes through its documents or it sees that there are a bunch of situations that are popping up, it should consider actually adopting a set of guidelines if there aren't already some in place, or even updating the ones that they already have in place to meet the association's particular and current needs. Now, we all know that, we deal with associations. Those associations are encumbered by restrictive covenants. And we realize that the reason why people buy into those communities is because they want to have a community that protects and preserves their property values. A person wants to go into a community that has these deed restrictions in place and know that in the future, they'll be able to sell their property at a high value. And this is also really important, especially here, like in Houston, where there is no zoning. Deed restrictions are really, really important because it does still put those rules in place so that there is some uniformity and some consistency to, a community. So zoning is a great thing in certain places, but since we don't have it, we have to really lean on our deed restrictions to make sure that we can keep those things out, like, a business next door to someone's home and things like that. So restrictions are really important in that sense as well. Now, here's just a reminder of the hierarchy of governing documents, and you guys have probably seen this slide from us before, but just keep in mind the controlling document, the most important document in the hierarchy, is really the plat. The plat map lays out the streets, the easements, the lots, and things like that in a community, and it also usually has some restrictions. So, for example, if there's a reserve in the community or a green space or something like that, those are typically designated on a plat. And then the next most important document is the restrictions. Again, we'll find those use restrictions that we're talking about in that document. We also will have the articles of incorporation or the certificate of formation. That's the document that actually creates the POA. The bylaws are documents that govern the actual governance of the POA. So those are the things that the board will actually look to determine how to govern itself. And then next on that list is the architectural or builder guidelines. So there's a bunch of other documents that hold a little bit more importance as far as the POA is concerned ahead of the architectural guidelines, but they're still very important. And then finally, you have rules and regulations and some policies. We've talked about those in other presentations, but today we're just going to focus on the architectural guidelines, because while those documents are not the highest priority, they're still very important. All right, so what do the guidelines do? Well, they actually provide owners with information on approval of such items. And so again, earlier I mentioned that a lot of times the restrictions will have certain information about use restrictions or how things can be built, the types of materials that need to be used, so on and so forth. But a guideline can really provide a little bit more clarity on things like colors of exterior paint, fence maintenance and requirements, landscaping, location of like mother-in-law suites or granny flats and things like that. And they should also address processes associated with obtaining project approval. And those guidelines should really be very easy to understand for both the POA and its members. You guys have no idea how many times we've run into situations where the guidelines are a little vague or they might be a little bit difficult to understand. And because of that, there is some sort of discord between the POA or the ACC and the members, because the members are saying, well, the guideline says this, and the ACC is saying, well, no, it actually says this. So it's really important to make sure that those documents are drafted in the simplest way possible and that they're easy to understand for everyone. All right, so guidelines can build on the underlying restrictions, but we have to ensure that they don't conflict with one another, right? They cannot contradict anything that's already existing in the restrictions. It should clarify. So there's some case law, and this is not as recent now as it could be, but this is still something that we rely on, where case law has told us that a covenant under review by a court cannot enlarge, extend, stretch, or change an already existing restriction. So in order to validly limit an owner's property use, the covenant has to plainly prohibit that use. So in other words, an owner who purchases a property for the value of that property, they can't, without notice of this restriction, they take the land free from the restriction. So in other words, that means that a person who is not notified of a certain restriction, they don't actually have to abide by that restriction in the court's eyes. Of course, that's not the case, right? We make the argument all the time that, even though a person doesn't necessarily know of restriction, it's filed in the real property records. That's just this court's interpretation. But an argument could come into play where certain guidelines may or may not have been properly adopted, and a person can say, well, these guidelines weren't in place when we bought this property, and as a result of that, we don't have to abide by the guidelines. Well, if you have restrictions that actually prohibit a certain activity or a certain, building things a certain way, then you can point to that and you can say, well, the guidelines are just an extension of the restrictions. The restrictions prohibit such things like, for example, painting your door purple. And the guidelines would say, well, instead of you saying you can only not paint it purple, then you can, the guidelines will say something like, well, instead you can make sure that it's painted in a neutral tone. or, you can line it with bricks or something like that. So making sure that it doesn't contradict is really, really important. Another thing too is if the association doesn't already have a set of guidelines in place, or it needs to update those guidelines, and I mentioned this before, it's important to get with the association's legal counsel, because what you don't want is a set of guidelines that might be too complicated, or again, that contradicts something that's in the restriction. So be cognizant of that. And we want to just make sure that we are creating a document that can actually be used and that's actually enforceable, so that the association doesn't have any trouble with doing that down the line. All right, so the association is empowered to enforce architectural restrictions that typically requires them having an architectural control committee in place, right? The ACC, the Architectural Control Committee, is a body that's charged with processing applications for improvement and determining whether applications comply with the applicable or the current restrictive covenants. Now, it's important, again, to check the governing documents for the POA's authority to actually create an ACC. I had a case not too long ago where a homeowner had been sent a 209 letter because they were attempting to add xeriscaping into their property rights. So that's the landscaping that controls flooding, or controls the amount of water that can exist on a property. And we were going kind of through it back and forth, and just so happened that the homeowners were actually attorneys as well. And so as I got into the governing documents a little bit to try to figure out, just make sure I had my mind wrapped around the entire situation, I realized that the governing documents for this particular association did not actually create an ACC. So it didn't give the board authority to create an ACC. And that was actually a huge problem, because there was an ACC that was existing as this entity that had the authority to approve or deny applications. And while there were other provisions of the restrictions that actually provided the association itself to approve or deny applications or review applications, there was no authority to actually create an ACC. So, there was architectural review authority, but it should have been maintained by the board. And that was something that we needed to kind of address and try to correct. And of course, there are provisions of the property code, which I'll talk about in a few seconds, that actually, bestow that architectural review authority upon the board itself. And then it gives the board the authority to kind of create committees, but that really needs to be contained in the governing documents, in the restrictions as well. So that's something that I would encourage everyone to kind of look out for, just to make sure that, if there is an ACC, which, the association should be entitled to have, make sure that it has the authority to actually create that ACC in the documents, because that's really important. All right, so of course we're talking about whether or not we should have an architectural control committee, and in general, the answer to that question is yes, especially if the governing documents do provide that authority to create an ACC committee and give that ACC the committee the authority to review applications. But if you don't have a smooth process, then that can end up being something that's just terrible all around, right? So we want to make sure that we do have a process or procedure in place that would make it very easy for homeowners to submit their applications and then for the ACC to review it. Of course, that procedure should be included in the ACC guidelines. And honestly, that should be the first thing that you put in the ACC guidelines to make it a little bit less complicated for a person to find out what that procedure actually is. Now, of course, we want homeowners to submit an application to the ACC, and the ACC application should really have certain requirements so that when the ACC is actually reviewing everything, they have all of the information that they need. So the application should really require homeowners to provide details on whatever the proposed construction is, including the materials to be used, what colors they intend to use, and things like that. If this is an application for some sort of landscaping, it should be owners should be required to include maybe the type of trees that they want to plant, or shrubs or whatever, because that would eliminate a lot of back and forth that can occur with these applications. And I'll explain in just a few minutes why that's something that we should try to do our best to kind of prevent. Now, another thing too is while we want to put the procedure for submitting an application into the ACC guidelines, we also want to make sure that that application is readily available to owners. We don't want a situation where an owner, it makes it too difficult for an owner to actually locate the application or even to submit the application, because what they'll do is if it's too hard for them to find it, then they won't fill it out and they won't submit it. So the application needs to be submitted on the association's website, or even, we recommend that the application be attached to the ACC guidelines or both, so that makes it easier for it to be accessed by a homeowner. All right, so I talked a little bit about the property code, but I think we all know, and we've talked about this a lot before, but previously it wasn't uncommon for the POA's board of directors to actually also serve as a member of the ACC. But that's all changed since 2021 because the property code was amended, and now there's a call for separation between the board of directors and the ACC for single family POAs. Now, this comes into play if there are more than 40 lots and the development period has already ended. So specifically, and this is something that we always like to point out, a person serving on the ACC cannot be a current board member. They cannot be married to a current board member, and they can't be living in the same house as a current board member. This poses a problem for a lot of ACCs who already have issues with, lack of enthusiasm or lack of participation by community members. But this is what the law is now. And so we have to try to do the best that we can to kind of engage the community to get them involved, right? Now, this might change. This statute was, of course, it came into play in 2021, but it may soon be amended by what was previously Senate Bill 48 that was introduced during the legislation this year. But also yesterday, we got some updates that this bill was refiled under a different bill number, and there will be a fourth special session. So this bill is going to be, or should be considered, might be considered in the fourth special session. So we just got that update yesterday, and we're hoping that it'll get passed then. We don't know what's going to happen. As you can see, we're now in our fourth special session, which is a little bit unusual. So maybe we'll have a fifth, maybe we'll have a sixth. We don't know, but this is still up for consideration. And it also includes not just this information about ACC members, but also security measures. And that's another big, hot button issue that we're all kind of looking forward to and hoping that that bill will get passed as well. So we're going to keep our eye on that, and we'll provide updates to everyone as we get them. All right, so I mentioned this a little bit, but part of the positives of establishing an ACC committee is because we can help to maintain efficiency for members of the community. Remember, the ACC committee, their sole purpose is to review applications that are submitted by homeowners for improvements or new construction or something like that. So it's really efficient to have a committee that only does that. Part of the reason why I presume that the legislation was changed was because they wanted to have this committee focus solely on, use restrictions and making sure that everyone on the committee was completely aware of what the different use restrictions might be and all of the guidelines so that they could more efficiently review applications and then keep that separate from the board so the board could handle board business. But also what it does is it establishes some new positions for community members to help with that engagement in the community, because as I mentioned, that's something that's it's lacking, and that's something that we've been hearing across the board. So in addition to maintaining efficiency for members of the community, it also establishes some consistency with the modifications and alterations in the community. Imagine if you have a huge community and there's not one central location where applications are reviewed, so there's no ACC committee, then it would probably be difficult to maintain some consistency with things that are approved, right? And you can imagine, especially with the larger community, that can be really, really complicated if the same eyes aren't reviewing applications, day after day or month after month, then consistency would be difficult. So part of the reason why we have community associations is because we want to maintain that consistency and, that uniformity. And so it's really important for an ACC committee to exist because it can help with that efficiency and consistency. It doesn't always, but it definitely is a step in the right direction. All right, so we've talked a little bit about the application, right? The submitting an ACC application for an improvement. So what does the committee do with these applications once they are submitted? Well, once that application reaches an ACC committee, then the committee needs to take the steps that are necessary to respond to the application within any applicable deadlines. Now, this is really important, so I want you guys to pay close attention. A lot of times deed restrictions have an automatic approval provision where any application that has not been approved or denied within 30 days, it's deemed approved. Now, this can be problematic for so many reasons, and it's important for communities to know whether or not they have this provision in their deed restrictions, because it has come back to bite a lot of communities in the butt if they are not aware that this provision exists. And primarily the reason why this is so problematic is because once that application is deemed approved, it becomes really, really extremely difficult, if not impossible, to require an owner to deviate from the approved plans. So if it is day 31, and sometimes we have these savvy homeowners who have read these restrictions, and they know that on day 31, if they haven't received any sort of response from the ACC, then that application is approved and they immediately go and start doing the construction, even though under other circumstances that application would not have been approved, right? So we want to make sure that we're paying very close attention to any sort of time constraints like this, and we're acting as quickly as possible when we do receive those applications. Now, during that review process, once that application is received, the ACC needs to take special care to analyze the application for compliance with the restrictions and with the guidelines, if there are guidelines in place. It is really important not to wait for that full 30 days to expire. Again, it's difficult for a person or for the association to try to make a person go back, if they already feel like their application has been approved. But if there are compliance issues with the application, then we need to address those immediately. Now, if there are no compliance issues, then the application would be approved, right? And we shouldn't wait 30 days to do that either. But if there are, then we do want to be able to have that full amount of time, if it's 30 days, 40 days, or whatever, to be able to reach back out to the homeowner to let them know, hey, there's some information that's missing from your application. There's some other compliance issue that you need to know about. Maybe there's some other condition that we need to express to the homeowner to let them know, okay, maybe your application will be approved if you provide us with this additional information. Now, if we know for a fact that there are issues or that this application absolutely would be denied, then we need to go ahead and make sure that we send out that written denial letter and just not wait for that full 30 days, because too many things can happen if we wait for that full amount of time. Now, if we're going to send a denial, the contents of the denial notice it varies, right, based on the type of POA that we're dealing with and whatever the specific provisions of the POA's governing documents are. Now, sometimes you may want to include the provision that their application violates, or the reason why the application would not be approved or why it's being denied. Because maybe the homeowner, wants to submit a new application, or maybe they want to appeal the application, or the denial of the application, which I'll talk about in a few minutes. Now, if you're not sure whether the application that's been submitted actually complies with the applicable restrictive covenants or the guidelines, or you have questions about what to put in the notice of denial, then it's a good idea for you to consult with your legal counsel, because they can help you make sure that you draft the proper document or review the application for any issues that it might have. But keep in mind that if you wait, if the ACC is waiting that full 30 days, then it's opening itself up to allegations of unreasonable delay, or that deemed approval, which can be very, very difficult to overcome. On rare occasions, an application that would normally be denied actually may require a variance from the POA, and a variance really should only be granted if the association has specific authority to do that. So we want to, again, check into our governing documents and make sure that the association actually has specific authority to grant a variance. And if you have questions about that, consult your legal counsel. But The governing documents sometimes will limit a POA's ability to grant a variance to situations where there's a hardship due to a particular nature of a property in question. So, for example, generally on a plat, you have rectangular shaped lots. But there was one association that I was dealing with where there was one lot that was actually shaped like a triangle. And it made it very difficult for this homeowner to abide by the setback restrictions, the minimum setback restrictions. And so because of the nature of the property, the association was willing to grant a variance as far as the setbacks were concerned to allow this homeowner to build a fence, right? So you got to take those sorts of things into consideration, kind of review the entire totality of circumstances, listen to the homeowner if they have some sort of, additional explanation about why they're requesting this variance. And if the association has the authority to grant the variance and the circumstances call for it, then probably can go ahead and do that. But if there's any question and you're not sure, consult your legal counsel. In the event that there is a variance that's going to be granted, then the POA's attorney, whoever that might be, can assure that that variance is properly documented and then that it's filed in the real property records. And I've had a couple of questions about why it should be recorded in the real property records. Well, the person who has requested the variance and been granted that variance may not live in that property forever. And so it's important that the variance be recorded in the real property records so that later owners of that property or anyone who has any sort of dealings with that property are aware of the fact that a variance was granted by the association. And so there's no question about the location of the fence or whatever that variance may be. So it's really important that those get recorded in the real property records. And so I was dealing with a case, this was back in 2020, right? In November of 2020, where there was an association was sending out 209 notices to a family who actually had already built a fence on their property. The problem with that was that the fence was built beyond the setback line, and then come to find out it was also built in an easement, in a utility easement area. And so eventually, after there was a lot of back and forth and the association realized that it had certain variance granting authority, the resolution of this case was to grant a variance on that property for the existing fence, but that at the point when that property would be sold, if it was ever sold in the future, that the fence would have to be taken down and restored to its original location. So a couple of issues with that, right? The homeowners failed to actually submit an application to the ACC in order to get permission to build this fence. But also, since the fence was already built, a court would not likely have them tear it down. However, due to the fact that it was in a utility easement, then the homeowner needed to be aware of the fact that if ever there was any situation where a utility company needed to come in and tear up that area, they would also tear up that fence, and then the homeowner would be responsible for replacing it or doing whatever they needed to do. So that's one reason why variances are important, because in this situation, that fence was in a utility easement, and whoever bought that property later on, once they realized that, they might think that there was an issue. But since we had a variance recorded in the real property records, then everything was fine with that. So that's a reason why variances are super important. So after we have submitted our application, the application has been reviewed, and now we're getting to the point where we're going to approve or deny an application. So let's say that we've approved it, and the homeowners can go ahead and start moving forward with the construction of their outdoor backyard kitchen, right? Well, the POA needs to really pay very close attention to that property after the application has been denied or approved or denied, because we want to make sure that the homeowner is not taking any liberties, right? They're not, doing something or having some construction done that was not approved or was not provided for in their application. Or if it was denied completely, then we don't want to, pass by the property and see them throwing up a kitchen in the backyard, right? In several instances, we see that POAs wait to take action against some sort of unapproved construction. Like if you have passed by this home and you see that they're building a kitchen in the backyard and you denied their application, that's an unapproved construction. We want to do what we can to prevent that in the early stages of it. because once the construction is complete or substantially complete, it's very, very difficult to convince a judge or a jury to require the owner to undo or remove the construction due to equitable concerns. In other words, it would cost the homeowner twice as much money to have built that kitchen and to now have to tear it down because the association maybe didn't take the precautions that it needed to at an earlier stage. So essentially, the point is compliance actions need to be taken as soon as possible after you've discovered them, before a significant amount of time, labor, money, or materials are expended by the owner, because a court will actually take that into consideration. Now, if there are extreme cases, of course, we might have to get the POA's legal counsel involved, but consider this, that during the process of construction, of course, we don't want any sort of unapproved or different sort of construction going on, things that were not in the application and things that did not get approved, but we know things come up, right? So during construction, there might be some need for a modification to the design that was submitted. And so the owner needs to make sure that they're following the ACC guidelines, because if there's something that's come up that was not in the original application, then maybe they need to resubmit another application for approval for this new issue that's popped up. So that's why it's important for the association or the committee to pay really close attention to properties that have submitted applications, whether they've been approved or denied, because we want to avoid having to spend a ton of money on litigation or avoid a situation where we cannot force a homeowner to undo some sort of construction that they've done without approval. Again, it's very difficult for us to convince judges and juries to make a homeowner spend a ton of money to undo something that they shouldn't have done. All right, so I mentioned there are some extreme circumstances. So if that happens, if you do see a person throwing up a kitchen in their backyard and there's, a stove coming in and, bricks flying all over the place, then reach out to your association's legal counsel, and we can do a couple of things, right? We can send a cease and desist letter. And if that cease and desist letter gets ignored, then we can file an application for a temporary restraining order, which would force the owner to come into court and force them to explain to a judge why they're proceeding with construction without getting approval from the association. All right, so our next topic is, how do we respond to a homeowner with delinquent fines or assessments? And this can be a tricky situation, right? Associations or the ACC committee might run into a situation where a homeowner is attempting to submit an application for some sort of modification or improvement, but they are delinquent in payment of assessments or fines. We get this question a lot. And the answer is, you got to look at the governing documents to determine whether or not the association has the authority to do anything in this situation. So there is no precedent in case law or statute instructing POAs on whether or not they should process an application if a homeowner is delinquent on fines or assessments. So you have to look to the declaration, and the declaration will tell you, or it won't, but if it does say, that the ACC or the board can deny an application based on delinquent fines or assessments, then the association can do that. It's well within its right to do that, and it should, right? But if there is no provision in the governing documents, then our recommendation is to have the ACC or the board just review the application based only on the restrictive covenants in the ACC guidelines, and not make any decisions based on the fact that the homeowner is delinquent on their homeowner account, right? So we just need to be cognizant of that. We get this question a whole lot, and it's important to know that if the association does have that authority, then it can exercise that authority, and if not, then it can't. All right, so what are our takeaways? And we've gotten through this pretty quickly, so that's great. Our takeaways for this are the ACC, with its architectural review authority, is a very important function for any POA. If we do have that committee, it is very important that we make sure that that committee operates as efficiently as it can, because it really adds a benefit to the association. It ensures that owners are able to make those modifications and improvements to their homes while they're still abiding by the restrictions of the POA and maintaining that intended character of the neighborhood. Again, remember, the point is that we want to do things that are consistent and uniform, because it helps us to maintain those property values, which all homeowners and property owners associations, they are all interested in doing that. And while it's a very important process, we want to make sure that that process runs as smoothly as possible. The association can do that by creating guidelines, making sure that that application is available. When the application is submitted, making sure that it is reviewed in a reasonable amount of time, and that if it's approved or denied, making sure you send out that notice to a homeowner to let them know why it was denied and give them an opportunity for an appeal if that's necessary. In another one of our presentations, we talk about the ACC appeal process and the ability for a homeowner to request a 209 hearing under 209 of the property code. So these are all things that kind of go into this same process. You know, owners do have those rights, and so we want to make sure that they know about them and we give them to them. But again, with the smooth ACC process, you know, part of this is the ACC. Part of maintaining this process very consistent and efficiently is so the association can maintain compliance. So we know that the homeowners are complying with the restrictions and that the ACC guidelines. Again, we're protecting those values and we are preserving the aesthetics of the community, which these are the #1 goals of a property owners association anyway. So with that, I am going to take a few minutes to answer a couple questions. Again, I want to make sure that these questions stay related to our ACC topic. And I do see that we have a couple here. Oh, we have more than a couple. Okay, so the first question is, how would the board approve applications if they don't have the ability to create an ACC? Aren't board members no longer allowed to be on the ACC? Right, so we need to look at the governing documents for this. If there is no ACC, then the board would potentially have the Architectural Review Authority. The goal is to have an ACC, but if there isn't one, we can't stop reviewing applications, right? Because homeowners are still submitting things. Now, there are a couple of ways to kind of avoid having the board do it. The association could hire a company to review their ACC applications. And so that's a good recommendation for anyone who does not have anyone stepping up to be a part of the ACC committee. Or it can bestow that authority to their property manager or something like that. So there are other ways to get around that, but we do need to still, if there is a committee, the committee needs to stay separate. If a recorded plat notes a second dwelling size, can the board or ACC still grant a variance to approve a different size? The second dwelling is not mentioned anywhere, and the board was not even aware of the note on the plat. This is something that I would probably have to look at the governing documents to kind of answer, Tracy, but I think the answer to that would be, if there is no indication anywhere else about what the second dwelling size should be, then you probably can go ahead and grant a variance. But what I would keep in mind is to make sure that this stays uniform. So if you're going to grant a variance for a specific size for one property, and another property comes and they determine that they're submitting an application for the same thing, then that second dwelling needs to be the same size. I might also encourage doing a board resolution for something like this, because if there is no provision, now you want to make sure that you address it, but also keep in mind that you don't want to do anything that's going to contradict your restrictions. So this might be a good question for your legal counsel. Since board members are no longer allowed to be on the ACC, how do we transition them out? You got to just cut them off. And should they still be reviewing and providing feedback on the ACC submission? So the answer to this for us is no. The ACC should have the full authority to review, approve, or deny ACC applications. So the board does not need to weigh in on that, because the ACC should have the full authority to do that. Janet has asked, can the board liaison be the one to conduct the appeal when the owner asks to be heard by the ACC? When denied, they request to be heard by the ACC, not the board. Board liaison, do you mean between the ACC and the board, Janet? I'll come back to that question. Provide a little clarity for me on that one. Okay, when the ACC gives permission to build a home that is in essence a duplex, what can other members of the association do to prevent that? The CCR specifically says single family dwelling, but it was still approved. Now that a precedent has been set, could the POA be in trouble for later construction? Yes. So you want to make sure that applications are not being approved if they do not comply with the applicable restrictive covenants. Because you're right, this does set a precedent, because later owners can come back and say, well, you allowed this homeowner to do it, so now I can do it, and then lawsuits can be filed. So there isn't really much that can be done once the application has been approved. As I mentioned, a lot of times judges and juries will not have a homeowner undo something that they've already done because of how much money it can cost, money and time and things like that. So that's why it's really important when you're reviewing those ACC applications to make sure it actually complies with the current and in place restrictive covenants. If the ACC needs more information about the project, does the 30 days restart once the ACC receives the information? No. So that's why it's important not to wait until the end of those 30 days. If the ACC needs more information about the project, it should make that determination early on, reach out to the homeowner to let them know. And then I would say if the homeowner doesn't provide the information that you've requested, then you need to send a denial of notice before those 30 days are up. What about when the documents specifically state that any applications with no response in a certain time frame are considered denied? That's fine. So there are provisions that say one or two things, right? They say they're either automatically approved or they're automatically denied. And if it says that they're automatically denied, then that's perfectly fine. Okay, if the 30-day period has expired and the request is then deemed approved, is there anything that can be done if the request does not follow the covenants? No. That's the reason why it's important to go ahead and respond somehow within the 30-day period. That is, of course, if the restrictions call for a 30-day period. If there is no such provision in the restrictions, then you don't have to worry about that. But you need to take a look at the restrictions to see if there is some sort of period of time that if it expires, then the application is deemed approved. So you can make sure that you work within that time period. If your documents have a statement such as aesthetically pleasing, how would you handle a denial for that? So this is difficult because that's very subjective, aesthetically pleasing, but I think the association's argument would be, here, let's look at the aesthetic of the rest of the community. And so we would say, we need to keep it consistent, but I would also recommend creating guidelines that kind of explain what aesthetically pleasing is, what that means, because it'll make it a little less difficult for the association to handle that phrasing, because that's a little complicated. 30 business or calendar days. It depends on what the restrictions say. If it says just 30 days, then I would say that means 30 calendar days. When I say real property records, do I mean that the records that the POA keeps? No, when I say real property records, I mean filed with the county or the state. So for example, in Harris County, it's going to be the Harris County real property records. Who should file the variance? The association should. This question, what are the real property records? Again, the real property records that are maintained by the county, so it becomes public notice, public record. Those things can be picked up by a title search or something like that. So that means that any person who purchases that property in the future has noticed that the variance was filed or was granted. Okay, we have a member who built a chain link fence when the CCR say no chain link fence is very clear. This was an early development of the community, so the member went to the declarant who gave him a variance. If that fence would have to be replaced, can the ACC deny the member to replace with a chain link fence, or has the precedent been set? I would recommend looking at the language of the variance. And if there is some sort of limitation on it that says, this chain link fence can only remain in place for as long as it's an operational chain link fence, and when it needs to be replaced, it needs to be replaced according to whatever the applicable restrictive covenants say. So this is going to be a legal counsel question, because a lot of things would need to be reviewed here to actually answer that question adequately. Can I explain equitable concern? Yes. So that means that the judge or jury would not likely enter some sort of judgment that makes a homeowner have to spend a lot of money or expend a lot of time and resources. So in my example about the kitchen, the outdoor kitchen, it costs a lot for them to install an outdoor kitchen, likely, but it also costs a lot of money for a homeowner to have that all removed and restore it back to the status quo or to how it was prior to them building it, right? So judges kind of frown upon making a homeowner spend a ton of money when it comes to things like that. Let's see, if the governing documents state that the ACC developer for, I'm not sure what this question is asking me. So if you could restate that one, then I could probably answer it. All right, Elaine says, what role should the property management company have in the ACC review process? That is going to largely depend on what your role is as the manager. I would take a look at your property management agreement or the management agreement between the association and the management company, and see if there are any certain roles that need to be played in the review process. But if there isn't, then I would say, the manager should help the ACC along, especially if it's a new ACC, to make sure that they're, getting through the process the right way. They're reviewing the proper provisions of the restrictions. And it could be like a training role just to make sure that they're handling the process the right way. If the ACC is not created in the governing documents, can the board do it? And how do you deal with the ACC denial hearings? So I would make sure that your governing documents actually grant the authority to the board to create an ACC, or that, an ACC is able to be created. Because I was kind of going along with the example that I gave. This association didn't have the authority to create an ACC, so they were running into some issues with the ACC's authority in general. So you got to make sure that there is the authority to create the ACC first. And if not, then we have to come up with more creative ways to have those ACC applications reviewed. I talked about earlier maybe having the property manager do it, or hiring a company to do that specifically. And so then when you have ACC denial hearings, they can still go to the board, because the idea is that they get appealed to the board. If the governing documents are silent to the amount of days the committee has to review, or there is no detailed application process, is the review time unlimited? So I would not recommend an unlimited amount of time. If it's silent as to the amount of days, I would still implement some sort of process where it should be no longer than 30 days, maybe 45 days tops. Because again, you want to kind of get that done as quickly as possible. You don't want it to kind of sit around and linger, especially if you start to realize that there are questions or something like that. You don't want it to just sit around. There are no state guidelines that limit the review time to 30 days. Any sort of limitation on the review time is going to be located in the governing documents. And if the documents are silent, are the applications automatically approved or denied if the committee fails to review in a timely manner? So the answer to that is no. There won't be any automatically approval or denial of an application if the documents are silent. But again, you don't want to wait forever to review them. It should be done in a timely fashion. And then I would recommend putting the procedure in place so that part of the reason why we encourage putting procedures in place is so that there is no question as to what the procedure is. Then that way the ACC knows what they're supposed to be doing, and the members know what the ACC is supposed to be doing, so that it can rely on the fact that if they submit an application, it will be reviewed and approved or denied in a timely fashion. Janet said, this is a clarification to Janet's question earlier. A board member is the board liaison for the ACC. Since an ACC member does not want to conduct the Zoom the owner has requested, the board member liaison for the ACC will handle the Zoom with the owner. Yeah, and that's totally fine. So that's something that can be done. Honestly, I prefer when there is more than one person that's present at the ACC hearings. And so maybe the property manager would want to sit in on that hearing too, so that the homeowner, feels like they're actually being heard by the board. But it can be one of those situations where the liaison then goes and talks to the board and lets them know this is what was said during the hearing, and then the board can make a decision based on that. Should the board members be sent notices that an ACC application has been approved? No, that's not necessary. The ACC committee should be handling all that. Can an ACC member inspect an approved improvement as it's being constructed? So it's difficult to be able to view something or inspect something that can't be seen from the road. You can always request permission if you feel like you need to actually get back there and see what's going on. But I would not recommend just going onto someone's property to inspect something, because you never know what could happen. The person's safety could be an issue, so we don't want to encourage that. Previous board president gave verbal approvals to homeowners for projects that did not fit the aesthetics of the community. Can we now ask them to submit an actual application? Yeah, so if there are verbal approvals, there's no proof of that. And so I would try to require that the homeowner submit an actual application. Now, if there are emails or something like that, then maybe you would consider allowing that to just kind of stay in place. But verbal approvals are not sufficient, and I would ask them to submit an actual application. Now, if those improvements are already completed, if they're already in place, then there isn't really much that can be done with that. But if they have not yet started, then I would request an actual application be submitted. If a request is denied and the owner proceeds anyway, even though he says he's not, what can the HOA do? So we can either send a cease and desist letter, or you can get the legal counsel involved and have them file an application for a temporary restraining order. That should stop the construction in progress until a court is able to make a determination as to what should happen with that improvement. ACC requested a form for tree planting. The owner refused the submission after reading the guidelines, which did not mention trees. Does the ACC committee interpretation take priority over owner interpretation? All right, so a lot of times there will be some sort of provision that says that the ACC has sole discretion over certain things, but I would caution the ACC against making decisions that do not gel with the restrictions, right? I have not read these provisions, so I can't be certain about this, but I would say if there aren't any mention of trees, then you might want to be a little bit cautious about that. But if there is a provision somewhere that mentions, like, the height of a tree or something like that, that can help you, you should take a look at that. But without me seeing the actual guidelines, this is a difficult question for me to answer. All right, so governing documents state that the ACC develops the GL's documents. In this case, the board gutted the document, deleted sections that clarified the document and compatibility clause. Now the board wants to record it without going back to the ACC for approval of the altered document. So generally the ACC does not, the board has the authority to amend certain things, right? So I would actually look at the document to see who has the authority to amend, first of all. If the board has the authority to amend it without any input, then they don't need to go back to the ACC for approval. But if the ACC has the authority to create guidelines, which sometimes it does, you just have to look in the governing documents to see who has that authority, then the ACC should be the ones to create those guidelines. And maybe they do need approval from the ACC. So you have to look at the language of your declaration. I have a few more minutes, so I'm going to get through as many more questions as I can. And then whatever else we don't get to, you guys can email me these questions. Okay, previous ACC was verbally approving builders to build a tiny home in the log cabin forest neighborhood. How can the new ACC prohibit the builders to continue building tiny homes? I would be very weary of verbal approvals because we don't know if those actually exist. For me, if there's nothing in writing, then you need to start the process and go through the process as it's recorded and as it's written. So I would not accept a verbal approval or someone telling me that there was a verbal approval. They need to submit an application. If the declarations allow for denial due to other other open violations, can the ACC deny solar panels? So solar panels are a very protected thing in the property code. There are certain provisions that basically say that the association cannot prevent an owner from installing solar panels, but that they can regulate them. So you need to look at the property code to determine what the association's authority is to regulate solar panels, but I don't think that the association can prohibit them under any circumstances. All right, if the ACC approves an application that is in direct violation of the governing documents, what should the manager or the board do? That is a problem because it sets a very problematic precedent because it's going against the governing documents. So I would recommend that the board or the manager step in. But if this approval has already been sent to the homeowner, then it's difficult to go backwards. So you need to make sure that the ACC understands that this application or any application that they get, before they approve it, they need to make sure that it is approvable, right? It needs to make sure that it's not something that's against the restrictions. What happens if a resident refuses to put in an ACC request after getting verbal approvals from a previous employee? We're getting a lot of questions about verbal approvals. If a resident is trying to rely on a verbal approval and they are refusing to submit an application, then I would have, okay, so we need to know whether or not there's already a violation, currently on the property, right? So they're refusing to submit an application, but have they started the project yet? If not, there's not an actual violation happening at the moment. But the minute they do start any sort of construction or improvement or whatever they're doing, then I would send a cease and desist letter. And if that gets ignored, then I would reach out to the association's attorney to get them to file an application for temporary restraining order. Okay, the guidelines previously did not state painting the brick was not allowed. Multiple properties were approved to paint, and the board then decided that this should not be allowed and amended the guidelines. And now is denying painting applications. They want the owners to remove the paint from the brick. The amendment was not provided to the owners. Should they still proceed with making the owners to remove the paint, even though others are allowed to keep it? So once a guideline is established, I would not recommend going and retroactively trying to get people to remove paint, because they painted the brick under the assumption that it was allowed. So the guidelines should really be enforced from the moment that it's recorded and going forward. So I would not have owners remove paint from brick that was already painted. And I would have them give owners notice of the amendment to the guidelines. So it needs to be posted on a website, or said in a newsletter or something like that, that there are new guidelines and here's what the amendment says. Because homeowners do need to have notice of the fact that there was some sort of amendment. Can the HOA charge back for cost of a cease or desist or restraining order? Yeah, so generally in the property code, the association has to send a 209 letter before it can seek any sort of reimbursement of attorney's fees. But there is an exception for a temporary restraining order, not necessarily a cease and desist letter, but a temporary restraining order. So if that happens, then yes, the association can add the cost for the restraining order to the homeowner's account. All right, so this is going to be the last one that I answer. Going back to variances, a previous and longtime ACC committee member was a committee of one and gave verbal approval for variances. Some owners fought him to get a written one. So that being said, there are several homes in the community which do not have a variance in writing. How can we go back and rectify that for filing with the county? That is a very interesting issue right there, because doing things retroactively is problematic. But it is important to have variances recorded or some notice of a variance. So if there is notice that a variance was granted, like in the association's records, then that might be sufficient. There's no requirement that the variance be filed in the real property records, but it is a strong recommendation. And so I think maybe, especially, first of all, with the verbal variances, that's terrible. But for the written ones, hopefully those are being stored somewhere or being kept somewhere so that they can be accessed sometime later in the future. If you do have written ones, then we could possibly go ahead and record them, but just make sure that the variance itself states, this variance was granted on whatever date. And so that whoever sees it in the future knows that it was granted, 2 years ago or whatever the case may be, but that we were just getting around to filing the variance in the real property records. All right, so it is 12:30 according to my watch. So I'm going to stop answering these questions. But again, if anyone has anything that I didn't get to or needs me to clarify anything or whatever, shoot me an email. My email is nhicks@rmwbh.com. And I appreciate so many of you joining us today. I love it when I have a huge audience. And you guys be safe. I'm sure the next time that we see you will be sometime in December or even next year. So you guys have a happy holidays and hope you get to spend some time with your family. And have a great rest of your day. Thanks, y'all. Bye.